Welcome everyone to Washington Legal Foundation's media briefing on the U.S. Supreme Court. My name is Glenn Lammi. I am Executive Director and Vice President of Legal Studies for the Foundation. This is about the 39th year, I think, that we've done this program. And we're pleased to have with us, as we always are fortunate to, a group of appellate experts and SCOTUS big thinkers to discuss this upcoming term. Pleased you have joined to spend the next hour of your busy day with us. As you may know, WLF is one of the most active amicus filers in the Supreme Court among public interest legal groups. Of the cases that our panelists will discuss, WLF has filed or will file in 7 of those cases. Of those 7, WLF supported the petitioner's successful cert petition in 4 cases. We'll get into those today. I want to introduce our panelists before we get started. Allyson Ho is co-chair of Gibson, Dunn's appellate and constitutional law practice group and a partner in the firm's Dallas office. She's presented over 100 arguments in courts across the country, including multiple state Supreme Courts, federal en banc court, the U.S. Supreme Court arguments as well. She served as a law clerk to Justice Sandra Day O'Connor on the Supreme Court and Judge Jacques Wiener of the Fifth Circuit. And we're also proud to include her as a member of WLF's Legal Policy Advisory Board. John Masslon is WLF's Senior Litigation Counsel. He joined WLF in 2020 after having served as Assistant Solicitor General for the state of West Virginia, where he regularly practiced before state and federal appellate courts. He also clerked for judges on the U.S. District Court for the Western District of Pennsylvania and the Superior Court of Pennsylvania. Lyle Roberts is co-head of U.S. Securities and shareholder litigation and a partner in the Washington, D.C. office of A&O Shearman. He represents companies, officers, directors, and securities cases and SEC enforcement matters throughout the United States. Lyle is a frequent pro bono contributor to WLF, and we appreciate that more than you can ever know, Lyle. We having recently authored our amicus brief at the cert stage and the merit stage of a case before the court this term that he'll be discussing, Facebook versus Amalgamated Bank. Finally, Aaron Streett chairs Baker Botts' Supreme Court and constitutional law practice and is a partner in the firm's Houston, Texas office. He's presented oral argument in the U.S. Supreme Court, 2 en banc circuit courts, Texas Supreme Court, and various federal and state appellate courts across the country. Aaron served as a law clerk to the Honorable David B. Sentel of the U.S. Court of Appeals for the D.C. Circuit and to William Rehnquist, who was Chief Justice of the Supreme Court at the time. I want to remind you that we are recording this webinar. If you have any questions, please use the Q&A function in the Zoom webinar toolbar. So let's start off with the cases from the October sitting. John, which cases scheduled for argument next month have a free enterprise implication to them?
So there are 3 main cases that have some free enterprise implication. The term will start off on October 7th with Royal Canine v. Walschlager, which is an interesting federal courts issue. The question is that when a plaintiff sues in state court raising both federal and state claims, and the case is removed to federal court, if the plaintiff then amends their complaint to remove the federal claims from the complaint, does the federal district court retain jurisdiction, federal question jurisdiction, and can it exercise supplemental jurisdiction over the remaining state law claims? There's only one circuit that has held that the federal court retains jurisdiction, and that's the circuit that the court granted cert from in this case. And if the court just reverses, I don't think there will be much impact, but if the court does affirm the Court of Appeals here, it could have a large impact, allowing more cases to stay in federal court, and you could see plaintiffs more hesitant to raise federal claims when they also have strong state claims in state court. The second interesting case is San Francisco versus EPA. This is odd in the fact that, San Francisco is the petitioner, and then you have both California filed an amicus brief on the side of the EPA and then a group of blue states. The question is about permits that are issued under the National Pollutant Discharge Elimination System, and whether those permits can say that you can discharge into the ocean or river, as long as the water quality standards are maintained, or whether the permit has to set specific limits on the discharge of those pollutants into the waters of the United States. This will have large implications because if the court affirms the Ninth Circuit here, what will be allowed to happen is that the EPA and states would be able to really kick the can down the road and just say, well, we're okay with you discharging, but you still have to maintain the water quality standards. It will make things much more difficult for those who do obtain these permits. And the final case of the October sitting that implicates free enterprise is medical marijuana v. Horn. So Horn was a truck driver, and he picked up a magazine in a coffee shop that had an advertisement for a CBD product called Dixie X. And the advertisement said that the Dixie X had 0% THC in it. So he ordered it, he took the Dixie X, and then because he has a commercial driver's license, he was subject to random drug tests, and he failed his random drug test. Because he failed his random drug test, he was fired by his employer. He then sued Medical Marijuana, who was the manufacturer of this Dixie X, and under RICO, arguing that that Medical Marijuana was a corrupt organization. And what the Second Circuit held was that even though there was no injury to property or business, which is required for a private suit under civil RICO, that Horn could sue because the personal injury to him resulted in an injury to his business or property because he was fired from his job. So essentially, the Second Circuit read out the requirement that civil RICO cases that plaintiffs must suffer an injury to their business or property and said, well, personal injuries are fine as long as they eventually lead to an injury to business or property. And obviously, you can go down the chain of events and eventually lead to some injury to business or property with respect to almost any tort. And so it would open up civil RICO suits to a vast array of different suits. And it could be one of the most important cases of the term with respect to business on whether civil RICO can be used in this manner.
Thanks, John. Moving into November, the court returns to the Federal False Claims Act with Wisconsin Bell versus U.S. X-Rail Heath. First of all, Allyson, thanks so much for joining us today. And what's the focus of that case, and what do you think it might be its broader implications?
Thank you, Glenn. It's a real pleasure to be here. And this is one of the cases that you highlighted at the outset, where WLF had filed a brief in support of the court granting. And as you know, Glenn, Heath is about the scope of the False Claims Act, a very old, very important statute that allows private citizens called relators to bring suit on behalf of the government when a defendant has allegedly defrauded the government. The case involves an FCC program called the E-Rate program, which subsidizes the purchase of telecommunications services by schools and libraries. That program is funded in a unique way. Telecom carriers pay contributions to a private nonprofit company called the Universal Service Administrative Company, which then disperses the money out to E-Rate participants. So the program is deliberately kept in private hands and walled off from the public fisc. In our case, a relator brought suit against our client based on submissions to the E-Rate program. And our argument is that the False Claims Act doesn't apply to those submissions at all because the act is designed to protect the government's money, but all the money in the E-Rate program is private. And just gets back to the fundamental point that the whole purpose of the False Claims Act, since its adoption during the Civil War, has been to protect government funds. Yet the lower court's decision in this case extended the act to wholly private funds for the first time. And that departure has constitutional implications too, as several justices, most notably Justices Thomas, Kavanaugh, and Barrett, have recently questioned the constitutionality of the provisions of the False Claims Act that allow private relators to stand in the shoes of the federal government and effectively enforce federal law. And those concerns are even greater, whereas in Heath, you have a private citizen going after private funds administered by a private corporation. And the case is the first time that the Supreme Court has considered the meaning of the definition of claim in the False Claims Act. That's a key part of the statute that affects every False Claims Act case. So we think this is going to be a very important decision for businesses and regulated entities potentially subject to False Claims Act claims going forward.
We'll stay with you, Allyson, on the next case, EMD Sales versus Carrera. The petitioner, along with WLF and several other amici, argued the decision below is an outlier. How do you think the court's going to approach this case?
Yes, to put it mildly, Glenn, outlier is the word. So EMD Sales is a wage and hour case about whether employers must meet a higher burden of proof to demonstrate that workers are exempt from the minimum wage and overtime requirements of the Fair Labor Standards Act, or FLSA. And so the Supreme Court is going to review a Fourth Circuit ruling that requires employers to prove by clear and convincing evidence that workers are covered by an FLSA overtime exemption. And as you highlighted, the Fourth Circuit stands alone in applying this heightened standard, with at least 6 other circuits applying the more typical and lower preponderance of the evidence standard. Now, interestingly enough, before the Supreme Court granted review in the case, it asked the Solicitor General to express the views of the United States on whether it should review the case. And the SG's office filed a brief urging the court to summarily reverse the Fourth Circuit in this case. That is, to reverse even without merits briefing, without oral argument, in light of what the SG's brief called the obviousness of the error. And WLF filed an amicus brief urging the court to reverse and restore uniformity among the circuits on this important issue of federal law. And the heightened standard is not only inappropriate, but I think it will also make it difficult for employers to demonstrate that an exemption applies, and will just result in additional unnecessary litigation to boot.
Are you surprised that the court passed on the SG's suggestion that it summarily reverse and instead granted cert in the case?
No, for 2 reasons. First, the SG's suggestion was very self-serving. The SG knows that it is going to have an avalanche of petitions at the court this term. And because the court's reduced docket, the SG wants to reserve those spots for its own petitions and doesn't want, an FLSA case taking up space. And second, on the other hand, the court wants easy cases like this that it's probably going to dispose of in a 5 or 6 page unanimous opinion that won't take that much effort. And that's kind of what the court is looking for in a lot of the business cases that it grants, where it can just have put on a front of unanimity while it's deciding the other high profile cases in a sharply divided manner.
The court in November also is going to hear 2 arguments within a week, 2 cases involving private securities fraud class actions. Lyle, before we have you talk about the specifics of the cases, this is a general area where the court has shown a good amount of interest in the past decade. Why do you think that's the case?
Thanks, Glenn, and thanks for having me on for this. There's really 2 reasons why the Supreme Court's interested in these cases. First, I think let's talk about the numbers. So there are roughly 200 securities class actions filed in the United States every year, and the vast majority of them allege that the company made misrepresentations in its public disclosures. that volume of cases means that in any given year, a company listed on a US stock exchange has about a 5% chance of being sued in securities class action. And last year, nearly a third of these cases were brought in the Ninth Circuit, which obviously contains the corporate headquarters of many publicly listed companies, especially in the tech sector. So I think it's safe to say that securities class actions are prevalent and costly part of our judicial system, and that the Ninth Circuit basically has an outside role in setting the law in this area. And both of the cases we're going to talk about are coming from the Ninth Circuit. The other reason for the Supreme Court's activity in this area is it really goes back to the law and how it got developed. So the vast majority of these securities class actions allege violations of Section 10B of the Securities Exchange Act and SEC Rule 10b-5. And these regulations prohibit the making of material false statements in connection with the purchase or sale of securities. But that's all they do. So what these regulations don't do is expressly provide for a private right of action that can be brought by a company's shareholders, nor do they define in any way the contours of such a private right of action. Instead, it was the Supreme Court that found that there's an implied right of action here. And the federal courts then have largely filled in the law around these cases, with some assistance, I should say, I guess, from the Congress in the Private Securities Litigation Reform Act of 1995. So, in thinking about this question for this panel, I thought, you might like this description I recently ran across in a treatise about this area of the law. I'll quote. It says, "It's difficult to think of another instance in the entire corpus juris in which the interaction of the legislative, administrative rulemaking, and judicial processes has produced so much from so little." So I'm really going to have to find a brief to stick that line into, but that's the baseline here, right? These cases, they're costly, they're consequential for the publicly traded companies, and because it's a judicially created cause of action, the Supreme Court has a particularly strong role in defining their contours.
So how does Facebook versus Amalgamated Bank sort of fit into that? You give us a little brief overview of that case.
Yeah, let me start just briefly with kind of the facts in the case, which we can cover pretty quickly. So in Facebook, the plaintiffs alleged that the company committed securities fraud when it stated in its Form 10-K filings that the misuse of personal user data by third parties posed a risk that could negatively affect the company. So in other words, this was part of the company's sort of standard risk disclosures about its business. What the plaintiffs contended was that at the time this risk disclosure was made, a misuse of Facebook personal user data by Cambridge Analytica, you may recall that whole scandal, had already occurred. And so it was not, in fact, a hypothetical. Actually, there had been a prior materialization of this exact risk, and that needed to be disclosed in order to make the risk disclosure not misleading for investors. So the Ninth Circuit looked at this and they ruled that Facebook's risk disclosure about the misuse of personal user data could support a securities fraud claim because Facebook had failed to disclose this Cambridge Analytica matter, even though there was no allegation in the complaint that the matter had actually harmed Facebook's business at the time of disclosure. In other words, that this prior materialization of the risk was actually material to investors at the time the risk disclosure was made. So the Ninth Circuit's ruling here diverged from the approach that had been adopted by several other circuits, including the First, Second, Third, Fifth, 10th, and DC circuits. All of those circuits had held that a company must disclose that a risk has materialized previously only if the company knows that the event will actually materially harm its business. A couple of circuits, and I think quite importantly, have gone even further than that. The Sixth Circuit and the Fourth Circuit, arguably, have held that companies need not disclose past events in their risk disclosures because those risk disclosures are inherently prospective in nature. That is to say, they are only forward-looking. They have no past connotation for investors. So why is this case important? Why are securities litigators really interested in it? Part of it is because securities class action litigation is no longer focused on events within the company's control. So historically, lots of securities class actions were based on financial restatements, so where the company itself discloses some kind of error in its financial reporting. But now there is a growing trend of what we call event-driven securities lawsuits brought by investors. And those are cases that are really brought based on external events. So data breaches, sexual harassment allegations, investigations, enforcement actions, stuff that the company itself is not disclosing necessarily, but is coming from outside the company. And when those events happen, the company may never have spoken about that exact type of event that's at issue, except in its SEC mandated risk disclosure. So the question of whether a company is required to include in that risk disclosure every time that risk has materialized in the past in order to avoid securities fraud liability is really an important one and will really affect how companies go about doing their risk disclosures going forward. And at the heart of it, I think this case is really a type of case that the Supreme Court tends to like because it presents arguably a really clear dichotomy. If a company says that something may happen in the future, can that statement be rendered misleading by not disclosing something that happened in the past? That's how I think I would boil this case down, and we'll stay tuned for what the Supreme Court's going to do with it.
But the second case, the securities fraud area, involves pleading standards for such class actions. What are the two questions presented here, and how do you think the court's going to address them?
So I'm going to ask you to indulge me just a little bit, Glenn, by giving a slight bit of the facts, because I think if you don't have those, we probably have a tough time with the questions presented. So let me try to do it really quickly. In NVIDIA, the plaintiffs alleged that the company had intentionally misrepresented the extent to which revenues for one of its products, a type of graphics processing unit, were attributable to purchases by video gamers rather than cryptocurrency miners. Now, I realize that I probably lost half of our audience the second I said cryptocurrency miners, but I swear you don't have to know exactly what that is. I certainly don't to understand the case. So, as a securities fraud claim, the plaintiffs here were required to adequately plead both that NVIDIA's statements about its revenues were false and that NVIDIA's management knew or were severely reckless in not knowing about the falsity of those statements. So to establish falsity here, the plaintiffs in the NVIDIA case did something a bit unusual for a securities class action, which is they included in their complaint the results of a third-party expert report they had commissioned to analyze the amount of revenue that the expert believed would have been derived from cryptocurrency miners as opposed to video gamers. To establish the required strong inference of scienter, that is to say, knowledge supporting fraudulent intent, the plaintiffs alleged that the defendants had access to sources of information internal to NVIDIA that reflected relatively high demand for this product from cryptocurrency miners. So while the plaintiffs alleged some specifics surrounding the documents, however, they didn't allege any specific information about what those reports contained, what exactly they said, beyond the fact that the company had received internal reports on the topic. So after the motion to dismiss was granted at the district court level, the Ninth Circuit considered both of these pleading issues and found that the plaintiffs had sufficiently pled their case. So in particular, what the Ninth Circuit found was that the expert report could be considered in assessing falsity because it was reliable and supported by other allegations. And second, that the CEO's, I'm quoting here, detail-oriented management style, unquote, coupled with his general tracking of the sources of revenue for the company would have led him to be aware of these cryptocurrency mining sources of revenue. In its cert petition, NVIDIA argued that both decisions contributed to existing circuit splits, and the Supreme Court granted cert on the following specific questions. As to falsity, whether plaintiffs can satisfy the PSLRA's, that's the Private Securities Litigation Reform Act's, falsity requirement by relying on an expert opinion to substitute for particularized allegations of fact. And as to scienter, second question, whether plaintiffs seeking to allege scienter under the PSLRA based on allegations about internal company documents must plead with particularity the contents of those documents. So why is the defense bar excited about this case? Really because it addresses something old and something new. So always a nice combination. So the new part is the aggressiveness in using an expert opinion to plead whether any false statements were made at all. So the Second Circuit and the Fifth Circuit have held that a plaintiff's expert opinion can't substitute for particularized factual allegations that tend to establish falsity. To the extent that the Supreme Court were to endorse the Ninth Circuit's more expansive acceptance of using an expert report like this, I think we're going to see it a lot more in securities class actions. That the plaintiffs are obviously, the bar is obviously going to take that as an invitation to really insert these into its complaints regularly. I think the inherent problem here is how does a court assess the reliability of the expert report on the face of the complaint? The Ninth Circuit said courts can do that. I'm not so sure. We'll see what the Supreme Court thinks about it. The old part is to what extent is the next question, which is to what extent a plaintiff needs to plead what is actually in the internal report that was shown to officers of the company, as opposed just to the mere fact that they received internal reports on the topic in question. In essence, that's a version of an issue that comes up in nearly every case. That is to say, the issue of to what extent is it sufficient to allege that the management must have known about the issue based on internal reports, as opposed to showing that internal reports actually contain contradictory information as to what, contradictory to what was actually reported to investors. So on this question, I think NVIDIA has a lot of circuit courts on its side of the split. And frankly, I'm hard pressed to believe that the court is going to accept that it's sufficient to point to the CEO being detail oriented and receiving reports without knowing anything about what's in those reports. But we'll see.
One thing I didn't note in my introducing Lyle is that he writes a fantastic blog, the 10b5 Daily, which I would definitely recommend to people who have an interest in this area. Well, Aaron, thank you for being patient and for joining us today. So we're going to move on to the unscheduled cases, ones that'll be argued in December or beyond. Some commentators have written that the case involving the federal NEPA statute, 7-county infrastructure coalition, might give the court an opportunity to apply the Loper-Bright precedent. Can you discuss what's at stake in that case and also whether Loper-Bright might figure in?
Thank you very much, Glenn, and thanks for the opportunity to be with you all. So the 7-county infrastructure case involves NEPA, the National Environmental Policy Act, which is designed to require federal agencies to take a hard look at the environmental harms that would be caused by some action that's being approved by the federal agency. And as a result of that requirement, the agency must create what's called an environmental impact statement that analyzes the effects of the action and considers options that may minimize the environmental effects. The problem is these things have become extremely long and burdensome. The average environmental impact statement now takes 4.5 years for the agency to complete. And in this particular case, which involves an 88-mile stretch of railroad in Utah, there was a 3,600-page environmental impact statement. So the risk of applying overly expansive readings of NEPA is that you tie up infrastructure in red tape for years on end. And the question presented in this case is, when NEPA refers to analyzing environmental effects from the agency's action, how far does the agency have to look? So this case presents in some ways an extreme example. This is, as I said, a relatively small stretch of railroad in Utah, but because it's going to transport crude oil, the DC Circuit held that the agency in this case should have analyzed issues like environmental justice on the Gulf Coast of Mexico, where the oil would be refined, and even upstream effects like how that oil would be extracted from the earth. Even though none of those effects are within the jurisdiction of the Surface Transportation Board, which is the railroad regulator at issue in this case. So we have one key precedent, and then we have a key bit of text that are key here. The key precedent is the public citizen case from the Supreme Court back in 2004. And while the NEPA itself, at least as initially enacted, does not say how far the agency needs to trace the effects of the agency action, the Supreme Court has said there needs to be a reasonably close causal relationship between the action and effect. It has said there needs to be a proximate cause between the agency's action and effect. Another way the court put it is a legally relevant cause, which I think is correctly read to mean if the agency doesn't have jurisdiction over the effect, then the agency doesn't need to analyze those effects. So taking a classic example, the Federal Energy Regulatory Commission regulates a pipeline. It doesn't regulate the fracking of the gas that goes into that pipeline. It doesn't regulate the refineries or the cars or the gas stations that ultimately use that gas. So the argument that the petitioners are making here the sponsors of the railroad, is that those are not legally relevant causes. The relevant text here is an amendment to the Builder Act, which just passed a couple years ago and was designed to reform NEPA and permitting processes. And that act spells out that the agency needs to consider, quote, reasonably foreseeable environmental effects of agency action. So it seems to constrain the scope and invokes ideas of proximate cause and sort of familiar concepts from tort law. And so the question here is, what do those words mean? We have a lot of old precedents from the Supreme Court and the DC Circuit that did involve Chevron and a lot of deference to agencies. But now we have, of course, Loper-Bright as the governing rule, and we actually have Congress stepping in and doing its job to some extent of enacting a relatively specific amendment. So there are a lot of ways the court could draw the line here. It could just say concepts of proximate cause are sufficient, and it could specify that that gives reference to issues that are within the agency's jurisdiction. Or it could take the more middle ground approach that the Solicitor General urges. The Solicitor General here agrees that the DC Circuit went too far in looking at Gulf Coast refineries and fracking, but it takes a much more nuanced stance. It would not expressly exclude things outside the agency's jurisdiction. It would just say that's a factor that the agency should consider in determining whether those effects are relevant. And it says the agencies should have discretion to draw, quote, manageable context-specific lines consistent with the underlying policies of NEPA. So as the Solicitor General often does, it's pleading, please give the government a lot of discretion to draw lines on a case-by-case basis, whereas the industry here is arguing for a bit more guidance that could streamline the NEPA process.
Another case that's going to be scheduled to be argued in December or probably January is the trademark action. Definitely sounds like a trademark action, Dewberry Group versus Dewberry Engineers. But there's a good chance that this decision might have broader implications beyond just the trademark context. Is that accurate?
So certainly could be, and I always love the names in the trademark cases. Dewberry versus Dewberry here. You can get a sense of the underlying dispute. And this case involves the Lanham Act, which in relevant part here allows a court to order disgorgement of the trademark infringer's profits. Subject to the principle of equity, the plaintiff may recover defendant's profits. That's the key phrase in the statute. Statute goes on to say that the court may, quote, in its discretion enter judgment for such sum as the court shall find to be just according to the circumstances of the case. So sounds like a very flexible context-specific test of the kind the SG might like. And the question is here, well, what about when the infringer's wrongful actions result not in profits to the infringer itself, but to the infringer's affiliated companies? And really what we're faced with here is which clause in the statute is the court going to give more weight to? Is it the phrase defendant's profits, which would suggest it's just looking at the corporate defendant that did the infringing? Or is it the reference to principles of equity and justice according to the circumstances of the case, which might suggest maybe defendant's profits could be read a little more broadly to look at affiliated entities' profits? Now, I think, as Glenn referenced, this does potentially have some broader implications. I think there should be concern anytime the court suggests that it may ignore the corporate form. That was, I think, a point very nicely made in WLF's brief in this case. We should also be wary anytime the court is effectively imposing liability on non-defendants to a case in the name of equity. We generally think of courts requiring a plaintiff to meet the high standard of piercing the corporate veil if the court is going to order relief against non-defendants, and that wasn't what happened here. Of course, on the other hand, we want innocent companies and victims to be able to recover the ill-gotten gains, and we don't want defendants to be able to use accounting tricks to shift those funds over to affiliated entities. Once again, the SG sort of takes a middle position here. could have some appeal to the court. The SG says, well, we're not asking you to read defendant's profits to mean somebody else's profits, but that phrase itself is broad enough to encompass funds that get booked by affiliates if there are certain internal arrangements between the defendant and the affiliates, such as below market contracts or accounting agreements that could support that reading. Now, of course, again, the brighter line rule, which may well appear to appeal to the conservatives on the court, is to say that there's an easy solution here. You don't have to stretch the text. You just require the plaintiffs to sue these affiliated companies for contributory infringement. Or you simply require the plaintiff to pierce the corporate veil if there's some sort of accounting monkey business going on. And therefore, you don't need to really read the statute so broadly. You can simply require the plaintiff to make these affiliated entities defendants to the case so you can directly go after their profits. So we'll see how that one comes out. I think it's one that has a somewhat unique statutory language that does reference equity. So I'm not sure how limited or how broad the holding will be, but certainly one to watch.
Thank you, Aaron. So we're going to talk a little bit about pending cert petitions. Allyson, you're counsel of record in an interesting ERISA case, and the firm is also counsel in a petition involving arbitration. Could you talk a little bit about those two petitions?
Sure. So let me talk about the ERISA case, which is particularly timely, as some of the ERISA files out there may know. We are in the year of the 50th anniversary of the statute of ERISA, and the case, which is up before the court on a petition for review, involves participants in a retirement savings plan who brought a putative class action alleging that the plan breached its fiduciary duty and engaged in what the statute refers to as prohibited transactions under ERISA merely by amending a record-keeping agreement in the plan held with third-party companies to expand beneficiaries' investment options, which is a service that plaintiffs conceded was necessary to properly administer the plan. The district court granted summary judgment to the plan, but the Ninth Circuit reversed, right? That's a phrase that those of us who practice the court, right? You feel like you're halfway home, right? If that's the next sentence. But the Ninth Circuit reversed, concluding that routine service agreements for necessary plan services are prohibited transactions under ERISA. And so holding, the Ninth Circuit panel departed from Supreme Court precedent and expressly split from the Third and Seventh Circuit's deepening and existing circuit conflict. And several amici in the ERISA space weighed in, explaining that the Ninth Circuit's interpretation of ERISA's prohibited transaction provision has the potential to impact the orderly and efficient operation of every retirement plan in the country. And in part, that's true because of ERISA's liberal venue provisions, which essentially allow plaintiffs a wide range of choices to bring suit, right? So it's particularly important in a statutory scheme where the court has again and again said, look, this is an area where uniformity is particularly important, and anytime you have a circuit as large as the Ninth that goes one way on an issue, then I think it's an important case to consider, because as the Ninth Circuit goes, so will go a lot of the litigation to follow. And again, it's litigation that has a particular importance, I think, to beneficiaries of plans themselves, who at stake are provisions of plans that provide important benefits to plan beneficiaries. So we will stay tuned and see how the court will treat that case.
In the case involving arbitration, that comes from California, correct?
Yes, and that case is another in a long series of cases which deals with sort of a very important feature of arbitration law and policy, which goes to the ability of states to essentially undermine ERISA provisions. And it's another instance of our friends on the West Coast, right? Sort of reaching out and sort of as the key question in this case and other cases that have raised the issue is we know that the federal law of arbitration reigns supreme, and so at what point does action by a state, whether that's a state legislature or a state court, at what point does that state action cross the line and interfere with a strong federal policy that favors our arbitration? So really interesting and incredibly important issue for the court to resolve.
Thank you, Allyson. So Aaron, earlier this year, the court asked the Solicitor General for his views on a petition that oil companies filed in a case where Honolulu was suing them for alleged climate change related damages. Can you tell us a bit about that case and what you think the government might end up saying in its brief?
Sure. So this case is a case brought by cities, counties, and states, particularly in Hawaii. And it's one of a large amount of these cases that have been brought across the country, usually in what the plaintiffs presumably think are sympathetic jurisdictions. California, Maryland, New York City, and Hawaii are some of the leading cases. Colorado is another case. And these are cases that, as Glenn mentioned, are brought against national and international oil and gas companies. And they allegedly seek redress for the harms caused by climate change and greenhouse gas emissions that harm those states and cities, counties, and governmental entities. In full disclosure, we do represent some of the petitioners in this particular case out of Hawaii. And in this case, the petitioners, who were the defendants below, moved to dismiss the state law cause of action. And the state law cause of action here is framed as a nuisance and deceptive marketing about oil and gas products and their propensity to allegedly cause climate change and the failure to warn of those outcomes. And the theory is that as a result of this deceptive marketing and failure to warn, individuals in these states and localities bought increased amounts of oil and gas products and therefore caused greater damage to the climate, greater damage to the property and infrastructure of those states. The defendants below moved to dismiss on the ground that such a claim is preempted by federal law, federal common law, as well as the Federal Clean Air Act. And the central theory is that it's really long been common ground that interstate emissions and interstate effects on the air are matters for federal law. They're not matters for one state to reach out and regulate a factory or a company in another state. Those things are simply matters for the national government to take care of. That's particularly true when you're dealing with international companies and international emissions. We don't want Hawaii telling an overseas oil company that they are committing tort violations with their actions overseas. We want the national government to handle that because of sensitivities related to foreign policy and international relations. Now, the plaintiffs say that they are not seeking to regulate interstate emissions, and therefore there's no preemption because they're just seeking to regulate deceptive marketing. Classic state law tort claim. They're not complaining about the emissions themselves. They're just complaining about the marketing tactics. Well, I think everybody recognizes that's an end run around the clear preemption of interstate emissions regulation. And that is borne out by the fact that the damages and the injuries that are alleged here are injuries from the emissions themselves. So this is really, would blow a gaping hole in preemption if this theory is allowed to proceed. But proceed it has in most courts around the country that are entertaining these cases. The one court that has taken a close look at this and gone in favor of the defendants is the Second Circuit in New York City versus Chevron, which involved the city of New York bringing a similar claim. And the Second Circuit said this is preempted by federal law. So the petitioners here, the oil and gas companies, have sought cert from the Hawaii Supreme Court decision affirming the denial of the motion to dismiss and holding that these claims are not preempted. The Supreme Court called for the views of the Solicitor General in late December of last year. I'm sorry, no, it was in earlier this year. And that suggests that the Solicitor General will be filing her brief sometime this fall. Would be the typical timing. Typically would aim for late December, mid to late December, so that the court could decide whether to grant the case by January, which would allow the court to hear argument and decide the case by the end of this term in June 2025. Now, of course, there's no guarantee the court will grant review in this case. The Solicitor General is very cautious about its credibility and which cases it recommends granting cert on. Generally, it opposes cert on CVSGs. Now here, there's some good reasons the SG should support certiorari. There's a real interference with federal interests, something the SG usually takes quite seriously. On the other hand, there are probably some political considerations that might push the SG in the other direction, perhaps particularly at the end of a presidential term. And another thing that weighs in the SG's consideration, as well as the court's consideration, is we do have an interlocutory decision here. We have a denial of a motion to dismiss from a state court, and the court, of course, all other things being equal, prefers to take final decisions. The argument that the petitioners are making here is you have a final decision on the relevant legal issue, which is preemption. No factual development is going to change the outcome on that dispositive legal question. So to me, the question here is going to be whether the court's concern about this particular species of litigation is great enough at this point in time to motivate the court to step in now, as opposed to waiting for another case or waiting for further litigation in the Hawaii case. And as our firm is counsel for some of the petitioners, we very much hope that the court appreciates the pernicious nature of this litigation and is willing to step in now and put a stop to it.
Thank you, Aaron. So in addition to supporting the cert petition in that Honolulu case, WLF filed a brief in a case where the nation of Mexico sued a U.S. company, and the First Circuit affirmed a very broad conception of aiding and abetting liability. John, can you tell us a little bit about the Smith & Wesson petition and WLF's brief?
Sure. So what happened here was Mexico sued Smith & Wesson and some other firearms manufacturers for public nuisance, arguing that the petitioner's sale of firearms in the United States caused a public nuisance in Mexico. So there was kind of like a 7-step process that they said led to this public nuisance. First, the gun companies sell firearms to wholesalers. Next, the wholesalers sell the firearms to federal firearms licensees. Then the federal firearms licensees sell the firearms to straw purchasers. The straw purchasers then either sell the firearms to smugglers or smuggle the firearms into Mexico themselves. Then the drug cartels buy the firearms from the smugglers. The drug cartels use the firearms to commit violent crimes in Mexico. And then this violent crime in Mexico causes Mexico to spend money on police and other security items. And according to Mexico, Smith & Wesson and the other gun companies should be held liable for this. And the First Circuit is allowing this lawsuit to go forward. They said that this chain of events was, quote, straightforward, which is just insane on its face. And obviously, the First Circuit is a very small circuit. It's the smallest circuit. It's the only circuit that doesn't have an active judge appointed by a Republican. And so you get decisions like this out of the court sometimes, especially in these cases that raise political issues like, guns rights. And even though this shouldn't be a guns rights issue, that's kind of how the First Circuit viewed it. What it actually is a case of great importance to free enterprise, because the aiding and abetting theory that the First Circuit adopted here was just extraordinarily broad. And the brief we filed in the case talked about why having such a broad aiding and abetting theory could lead to problems for legitimate enterprises. For example, there's no stopping the same type of chain of events from having somebody in the UK, say the government of the United Kingdom of Great Britain and Northern Ireland, sue for a stabbing that occurs in the UK. That should obviously be dismissed, but under the First Circuit's aiding and abetting theory, it's allowed to stand. Our brief also talks about the need for proximate cause in tort law and how proximate cause plays an important role in limiting liability for companies and individuals that take actions and then indirectly somehow cause another's injury.
So I'll finish up with a couple of questions that are sort of tangential to the court's docket, but will potentially have an impact on how the court manages its affairs this term. Over the summer, the court was forced to deal with another instance of leak to the media. So I'll ask Allyson and Aaron, since you both clerked on the court, how disrupting do you think this can be to the court's business? Allyson, you go ahead first, and then Aaron.
Sure. And I guess I'd just like to begin by saying how concerning the leaks are to those of us who have had the privilege of clerking at the court and who now enjoy the privilege of practicing before the court. It is a collegial court. It is a court based on a lot of trust among the justices and the law clerks and the staff of the court as the court goes about its business. It's about its decisional processes. And so I wouldn't want to speculate about the effects of the leaks inside the court. I can only imagine that it strikes a blow at the court. But ultimately, I have a lot of faith in the court. It's under attack now from a lot of different quarters, very unfairly in my view. But those of us, again, who have had the privilege of clerking and practicing before the court know the sense of responsibility and good faith with which all of the justices approach their work. And I have utmost confidence that whatever winds are buffeting the court, the Chief Justice and the justices of that court will rise to the occasion and do their duty and fulfill their oaths.
Thanks for your thoughts on that, Allyson. Aaron, you care to add anything?
Well, I agree with Allyson on her comments, and I guess I would just observe the different nature of this leak from the leak of the Dobbs draft opinion, where we got a fully baked opinion, but we didn't know really anything about the interior workings of the court to get to that opinion. The leaks that we had this past term were leaks about the internal processes of the court, initial votes, initial opinion assignments and changes to those opinion assignments, comments that were sent back and forth between justices. So I think in some ways, these types of leaks are equally as damaging and very concerning to the internal operations of the court. And I'm sure the court is taking steps to secure itself against leaks of opinions. We haven't seen any more of those, but it's much more difficult to secure yourself against the leak of one person talking to the media about something that he or she observed physically and then decided to pass it on. And I don't know what the answer is to how the court will deal with that. But it is a sad commentary that the trust that we all took so seriously when we clerked seems to be breaking down to a certain extent within the court.
Thank you, Aaron. So I can't end this proceeding without asking this question, which is, John, what do you think the chances are the court's going to get dragged reluctantly back into election-related litigation during this some part of this term?
100%. I mean, there's no doubt that we are going to see an avalanche of activity on the shadow docket regarding different rulings by both state and federal courts. We are going to see a lot of opinions on the shadow docket about application of the Purcell principle. What will be more interesting is kind of decisions from state Supreme Courts. My guess is that the court is going to try to avoid granting any petitions on those and instead answer them all on the shadow docket. But unless they're going to set argument for one of those, the most likely thing that's going to happen is they're going to deny the applications from the state Supreme Courts, but they will be granting a lot of applications from federal courts and applying the Purcell principle to those applications.
For those of us who are ignorant about what the Purcell principle is, could you explain what the Purcell principle is?
Essentially, it says that when you're, quote, close to an election, that federal courts shouldn't interfere and make last-minute changes to the rules regarding election cases. It's a well-settled principle that's been applied for about 50 years now, and courts are not, federal courts at least, should not be going in and changing the rules at the last minute. It doesn't technically apply, to state courts or to state legislatures. So I think it's much less likely, again, that you'd see something out of that.
Well, right at our end of our program here, time-wise, so I want to thank everyone for joining us that viewed this online. Thank you to each of our participants as well, and I wish everyone who's participating in arguments this term or has cases for the term best of luck, and everyone else enjoy the term.